Jana Abu, New York Times versus Sullivan. Week 2 assignment, research case presentation. New York Times versus Sullivan. Who are the parties to the case and what facts led to their dispute? The parties to this lawsuit are the New York Times Company versus L.B. Sullivan. The facts that led up to the lawsuit are as follows. Respondent, an elected official in Montgomery, Alabama, brought a suit in a state court alleging that he had been libeled by an advertisement in a corporate petitioner's newspaper, the text of which appeared over the names of the 4 individual petitioners and many others. The advertisement included statements, some of which were false, about police action allegedly directed against students who participated in a civil rights demonstration and against the leader of the civil rights movement. Respondent claimed the statements referred to him because his duties included supervision of the police department. The trial judge instructed the jury that such statements were libelous per se, legal injury being implied without proof of actual damages, and that for the purpose of compensatory damages, malice was presumed, so that such damages could be awarded against petitioners if the statements were found to have been published by them and to have related to the respondent. As to punitive damages, the judge instructed that mere negligence was not evidence of actual malice and would not justify an award of punitive damages. He refused to instruct that actual intent to harm or recklessness had to be found before punitive damages could be awarded, and that a verdict of respondent should differentiate between compensatory and punitive damages. The jury found for the respondent, and the state Supreme Court held, a state cannot, under the First and 14th Amendments, award damages to a public official for defamatory falsehood relating to his official conduct unless he proves actual malice, that the statement was made with knowledge of its falsity or with reckless disregard of whether it was true or false. Why did Sullivan feel his reputation was damaged by the New York Times publication? Sullivan, being the police commissioner, assumed that any reference to the action of his police department were his own actions, since he was the head of the department. There were some untruths in the advertisement, so Sullivan thought they were a direct derision of his character and hence his good reputation in the community. What must a plaintiff show to prove defamation? There are 2 things that you have to prove to be true in order to win a case of defamation of character in the court of law. First of all, you have to prove without a doubt that what was said or written about you is not true. Once you have proved that the statements is in fact false, you have to prove that the other person said the false statement with the intent of causing you some harm. What was the U.S. Supreme Court's decision, and why did it make the decision? We hold today that the Constitution delimits a state's power to award damages for libel in actions brought by public officials against critics of their official conduct. Since this is such an action, the rule requiring proof of actual malice is applicable. Applying these standards, we consider that the proof presented to show actual malice lacks the convincing clarity which the constitutional standard demands, and hence that it would not constitutionally sustain the judgment for respondent under the proper rule of law. The case of the individual petitioners required little discussion. Even assuming that they could constitutionally be found to have authorized the use of their names on the advertisement, there was no evidence whatever that they were aware of any erroneous statements or were in any way reckless in that regard. The judgment against them is thus without constitutional support. There was no reference to respondent in the advertisement, either by name or official position. A number of the allegedly libelous statements, the charges that the dining hall was padlocked and that Dr. Martin Luther King's home was bombed, his person assaulted, and a perjury prosecution instituted against him, did not even concern the police, despite the ingenuity of the arguments which would attach this significance to the word they. It is plain that these statements could not reasonably be read as accusing respondent of personal involvement in the acts in question. We hold today that the Constitution delimits a state's power to award damages for libel in actions brought by public officials against critics of their official conduct. Since this is such an action, the rule requiring proof of actual malice is applicable. While Alabama law apparently requires proof of actual malice for an award of punitive damages, where general damages are concerned, malice is presumed. Such a presumption is inconsistent with the federal rule. The power to create presumptions is not a means of escape from constitutional restrictions. Bailey versus Alabama. The showing of malice required for the forfeiture of the privilege is not presumed, but is a matter of proof by the plaintiff. Lawrence versus Fox, Michigan. Since the trial judge did not instruct the jury to differentiate between general and punitive damages, it may not be that the verdict was wholly an award of one or the other. But it is impossible to know in view of the general verdict returned. Because of this uncertainty, the judgment must be reversed and the case remanded. Stromberg versus California, Williams versus North Carolina, Yates versus the United States, Kramer versus the United States. References. www.casebriefs.com and www.thelawdictionary.org.